We rocking, dog. We rocking. We moving. We rocking, and there's no games. No games being played. No more games being played with these white people. We going to court. It's time to start suing these motherfuckers for everything they got every time they do something. That channel was for the people. You done took all of this knowledge out the people mouth. How you gonna do the people like that? How y'all doing the people like that? Huh? Y'all gonna just do the people like that? We see you bitches in court. This will be added to the lawsuit, and I need my bag. I need my bag. You may very well be witnessing the end of an empire. Because I'm not gonna stop until I own YouTube ass.
What's going on, guys? It's your girl Angie Snatch coming at you with another episode of An Unbiased Truth. Welcome back to the Snatch Gang and welcome to all my new subscribers. I know last week I said I had a sinus infection and I think that I'm over it. Thank you so much to everyone that gave me all of the advice. So I think I'm over it, but I still have, like, I don't know, the sniffles or something. The sniffles. So I've never had sinuses in my life, but the doctor said that it can come in a
know
moment.
that.
So
I don't
thank
know
you
that. Also,
so much
four
to
of his sons
everyone
also
for all your advice.
was like,
I
hold
have to
up.
work through this.
I don't know
So
this history,
today we're
y'all.
going to be doing
But
part
Sonetta is
2
totally
of the
sweeping
Young
under
Pharaoh versus YouTube case. Quick recap. Last year, Young Pharaoh filed a lawsuit against YouTube. He raised over $96,000 with over 3,000 subscribers. Check out episode 34. That will catch you up on where I am right now, as this is part 2. Someone made a very fair comment that while I'm saying $96,000, that could not be possibly not be the sum total of what he actually raised, because I don't know his PayPals, Cash Apps, Venmos, and whatever other source that people possibly use to donate to him. Now, what I will say so far, this case has been dismissed, so we're going through a timeline. However, he has filed an appeal, so the case is still ongoing. As for those first set of people that donated, I would say that he did not scam you out of your money, but he definitely probably wasted your money. So on episode 34, we heard testimony from Chris Armenta, who is Young Pharaoh's attorney representing him in this case. He is a plaintiff in this case, just for clarity, because we know that he is a defendant in other cases. He is a plaintiff in this case. Chris Armenta, one of her specialties is the censorship of conservative content creators. And I think that we can safely say that Young Pharaoh is or can be considered a conservative content creator, especially with the type of exposés that he does when he puts his glasses on and things like that. So, what we're going to listen to today is Lauren White. Lauren White represents Google YouTube. What she's arguing in this response to the plaintiff's request that the judge does not dismiss the case is that the plaintiff sort of moves the goalpost, that Young Pharaoh moves the goalpost. As for the reasons why they feel like that the complaint should be dismissed, they state 5 reasons: that the plaintiff fails to state a claim under the First Amendment, that the plaintiff fails to state a contract-based claim, and that the plaintiff's quasi-contract claims fail as a matter of law. Plaintiff fails to state a claim under the UCL, that's the unfair competition law in California. Plaintiff fails to state a claim, plaintiff cannot evade Section 230 or the First Amendment. Go back to episode 34. I explain what Section 230 is. Now, with these 5 reasons why they feel like that the complaint should be dismissed, they feel like that YP does not rise to the occasion when it comes to First Amendment because YouTube is a private entity and they do have a right to oversight. And if they deem content not appropriate for their users, they have the ability to deny a person from creating content on their platform, as well as the fact that young Pharaoh initially says that they violate his contract and his First Amendment right. Once the judge isn't buying that, which you heard in episode 34, that is when they take that transition to say that YouTube is now a state actor acting on behalf of the government. Now, I want you guys to listen to what YouTube's actual response was. Even easier. YouTube does not receive federal funds conditioned on its acting in ways that allegedly harm plaintiff, nor are there any other laws, regulations, or government contracts that even arguably mandated or encouraged the removal of plaintiff's videos. And as in Heineke and George, there is no allegation that any government actor instructed or urged YouTube to remove, restrict, or take any other action in regard to Daniel's videos. To the contrary, the statements from Adam Schiff and Nancy Pelosi on which plaintiff relies include no demands or even requests related to the removal or demonetization of videos, no threats if YouTube failed to remove content, and certainly nothing whatsoever about Daniels or his videos. I just want to pause really quick. So one of the things that young Pharaoh was arguing was that when Nancy Pelosi was saying use social media sites, you will pay, that she was specifically talking about him, even though we know all that was going on. And I'm sure it was about a lot of content creators, but what they're arguing is there was no mention of a young Pharaoh Marshall Daniels. So it is very far fetched to say this blatant statement that was broadcast across CNN, Fox, MSNBC, and YouTube was directly towards us deleting Mr. Daniels' videos. To the contrary, the statements from Adam Schiff and Nancy Pelosi on which plaintiff relies includes no demands or even requests related to the removal or demonetization of videos. No threats if YouTube failed to remove the content, and certainly nothing whatsoever about Daniels or his videos. See Complex X, A, and B motion. The problem is not only that Mr. Schiff and Ms. Pelosi did not identify Daniels by name, but rather that nothing in their statements made any reference to his content, much less compelled defendants to remove his videos or made the federal government a joint participant in defendants' decision to do so. The facts that, I'm at line 14, guys. The facts that plaintiff emphasizes only highlight the implausibility of his story, that YouTube's CEO tweeted in response to Mr. Schiff that YouTube would consult with members of Congress, this is what he alleges, regarding issues around C-19, in no way suggests coercion or impermissible joint action, nor does Mr. Schiff's choice of stationery suggest that he commanded a particular result in or otherwise participated in Mr. Daniels' case or otherwise turned YouTube into a government actor. Google's self-regulation, even on topics that may be of public concern, does not implicate the First Amendment. The sentiments of individual legislators do not change that reality. Were it otherwise, Google, YouTube, and many other online platforms would be constitutionally prohibited from moderating even highly objectionable. I'm sorry, guys. Objectionable, offensive, or dangerous user content in any manner consistent with the expressed views of certain members of Congress. This is not the law, and accepting plaintiffs' unprecedented theory would eviscerate defendants' own First Amendment rights in the robust sphere of individual liberty that the state action doctrine is designed to protect. Plaintiff fails to state a contract based claim, and this is like the meat for me. In attempting to defend his contract based claims, plaintiff manufactures a sideshow about supposed ambiguities in the agreements and policies that accompanied YouTube's motion. But while plaintiff does not actually identify any such ambiguities, none of this is responsive to the arguments actually made in defendant's motions or to the issues now before the court. The complaint alleges that plaintiff's contract claims are based on the current version, and let me read this footnote for you guys. Because the footnote is where the attorneys can be a little more opinionated and not as matter of fact. Unable to offer an actual connection to Mr. Schiff and Ms. Pelosi's statements, plaintiff makes a convoluted argument that the time sequence alleged in the complaint is evidence that YouTube must have taken action against Daniel's videos because of those statements. While such baseless speculation would not in any event establish state action, the timing actually cuts further against plaintiff's theory. With respect to plaintiff's video accusing the doctor of murdering MFers and causing medical illness since the 1980s, for example, the complaint alleges only that Mr. Schiff sent a letter concerning vaccine misinformation on February 14, 2019, more than 14 months before plaintiff's video was live streamed on April 21st, 2020. That's a typo. It's supposed to be 2020. So, what happened is Adam Schiff, Congress sends out this notice about misinformation about vaccines. Not what we're dealing with now. Prior to this, because this is February 14th, 2019, that this happens, that he sends this out. Mr. Schiff does. So, then in April 21st, 2020, that's when young Pharaoh has the stream. So they're saying basically it's not connected. But there's another incident that is named. As for Mr. Schiff's April 29th, 2020 letter concerning C-19 misinformation, the complaint does not even allege that statement preceded the video's removal, nor could it. And Ms. Pelosi's public statements to social media executives that you will be held accountable allegedly came even later at a Georgetown forum in June 2020. So, what young Pharaoh's case first said was that they were in breach of a contract and committing fraud and violating his First Amendment rights. Once that case was not dismissed, but that's what they initially filed their motion to dismiss for, then young Pharaoh's attorneys came back and said, no, you did it because of pressure from these politicians. So now YouTube, Google is responding again, showing that there is no connection, and the judge clearly bought it, that there's no connection between what young Pharaoh is now alleging the second time, because remember, this is a modification. The first time they were committing fraud and violating his First Amendment right. Once the judge wasn't buying that, they came back with the second part of the complaint, which I don't know how they could do that. That's probably why it got dismissed. You kind of got to stick with what you decide in the beginning. However, that happened. Comes back with a modified, well, no, you can't dismiss it because of that. And that's what you heard my sister and I read in episode 34. YouTube's terms of service. A valid contract to wit YouTube's terms of service for content creators exists between the parties. The contract can be found at accepting the allegation that this is the relevant contract. Plaintiff has failed to state a claim for breach. Plaintiff focuses primarily on YouTube's decision to remove his two videos from its service. But as defendants explain, the terms of service give YouTube the right to do precisely that. Plaintiff homes in on the provision that's stating that YouTube may remove content if it reasonably believes that content is in breach of this agreement or may cause harm to YouTube or users or third parties. Sidebar. This is why, yes, having a website is important, but YouTube should be used as a mechanism, and you should not, in my opinion, do this exclusivity. If the information is important, you get it to the people. But if you understand censorship in Section 230, then you create another platform, website, somewhere to all for people also to find it. But let's be real, when we purchase our phones, YouTube is on it, so it is a way to get out the information, but it is a private company. So for some of the things that young Pharaoh wanted to say, he needed to do it on Nation. It's like playing chess, understanding how each of the pawns move on the board. I don't know how to play chess. Wrong analogy, sorry. Plaintiff focuses primarily on YouTube's decision to remove his two videos from its service. But as defendants explain, the terms of service give YouTube the right to do precisely that. Plaintiff homes in on the provision stating that YouTube may remove content if it reasonably believes that the content is in breach of this agreement or may cause harm to YouTube, our users, or third parties. Plaintiff argues that this provision creates a factual question that cannot be resolved on a motion to dismiss. That simply is not so. As an initial matter, while the reasonable belief provision expressly confers authority on YouTube to remove content in its discretion, it does not impose an obligation on YouTube to host or display content in all other circumstances. To the contrary, plaintiff races past the separate but equally relevant provision that makes clear that YouTube is under no obligation to host or serve content. YouTube would not breach the contract by removing content it is under no obligation to host in the first place. Ooh, messy, messy. But even putting that aside and focusing on the reasonable belief provision in isolation, there is no factual issue. Plaintiff simply has not alleged anything to plausibly suggest that YouTube lacked a reasonable belief that the two removed videos were in violation of the terms of service or might have caused harm to YouTube or others. Plaintiff's videos speak for themselves, and the complaint itself acknowledges YouTube's determination that those videos violated its community guidelines, including its policy against harassment and bullying. Plaintiff's apparent disagreement with YouTube's policy decisions does not create a fact issue or deprive YouTube of its contractual right to remove content. That is especially true here, given that plaintiff's whole theory is that YouTube acted in response to threats from legislators and out of fear that Congress would, among other things, pass legislation injurious to their business. While this does not create state action, it does make clear that, under plaintiff's version of the facts, YouTube's removal of Daniel's videos fell squarely within the discretion expressly conferred by the terms of service. On plaintiff's own story, that is, YouTube acted under a reasonable belief that Daniel's videos may cause harm to YouTube. Beyond the question of removals, as defendants explain, the terms of service make no promises about monetization, payments, or appeals. The terms of service say nothing about advertising or other revenue. As for appeals, while the terms of service direct users to YouTube's Help Center to learn how to appeal, they make no promises about that process, such as a certain outcome or time within which an appeal will be resolved. Nor do they promise to inform users of removals or the reasons for them. Within any specified time period or through any specific channel. Plaintiff's arguments cannot change this reality. According to the complaint, YouTube communicated that plaintiff's videos were removed for violating YouTube's community guidelines and policies, and plaintiff appealed those decisions. Insofar as plaintiff expected a more immediate or specific explanation for YouTube's removal decisions or a more rapid appeals process resolving in his favor, these wishes have no support in the agreement. Moreover, plaintiff does not and could not allege to have suffered any harm as a result of YouTube's supposed failure to provide a more prompt or specific reason for its removals. Such allegations cannot give rise to a claim for breach of contract, nor can an implied covenant help plaintiff here. This theory, too, is based on the current term of service, but plaintiff does not explain how such a claim is not duplicative of its breach of contract claim or equally valid. So basically what they're saying is sorry. Let me get some water. Yes, I have to rest again. Okay. So basically what they're saying there is just because we didn't do it your way, it is not Burger King. We are sorry we did not get back to you quickly enough. Yes, we still believe that your content was in violation and harmful to our community. And until you create a platform in which you can control your content, then sorry for you. It's basically what they were saying there, honestly. You got to be like Oprah and buy the network if you want to control what's on the network. And none of us own YouTube. I know that we have a lot of people that support us and followers and like-minded thinkers, but we don't own this. This is like a gathering space for all of us. And I think young Pharaoh kind of learned that the hard way when Miss White came back to him. Because remember, I told you guys before, when you file a case, you really do have to show how you were damaged. How did your life change? What was the shift? Now I just lost my channel. Like, all of those things are important in building a case. Now, he is appealing it. This case was dismissed because the judge did agree with Miss White and Miss White's argument that they did not violate his First Amendment, that they did not violate his contract, that there was no civil claim to be made, that there was no unfair competition law violated. In a nutshell, did he take the people's money? I still can't say that. I still can't say that. I know you guys have told me about other scandals, and maybe if I look into them, but I still can't say he took the people's money. What I can say is he wasted the people's money, because if you can raise $96,000 and then some, you can wait and build your case and make sure that when you go after these people who have wronged you and your community and your people, so you say, that you would come to them with a full throated claim and complaint against them. Because, in a way, yeah, the people's money was wasted, because to fight this appeals case, there's going to be more money needed. And like I said, he's a plaintiff in this case, but defendant in other cases. So that's a lot of money for a lot of attorneys, when this money probably could have been used more efficiently and effectively if you sat back and really gathered this case to see if you even had a claim, or use the money to build that network that I'm being cynical about when I say that. Uh, I'm going to take care of myself now. All right, guys. I'll talk to you later. It's your girl, Angie Snatch.